An assessment appeal hearing is not as formal as a proceeding in a court of law. The hearing may be held before an appeals board panel or a hearing officer in a conference room or in a larger meeting room. The rules for the hearing are the same regardless of the type of room they're held in and will be explained to you prior to the start of your hearing. Many counties have adopted local rules of procedure governing the assessment appeals process. Prior to your hearing, you should ask the clerk of the appeals board for a copy. If you don't understand a procedural rule or issue, please ask the clerk for clarification. And if you need a clarification during the hearing, don't hesitate to ask the appeals board for clarification as well. They'll gladly explain the process so that you know what to do. The appeals board or hearing officer will be seated so that information being presented by you and the assessor's representative can be seen and heard. At a hearing before the appeals board, there will be a clerk present and a recording device may be used to record the hearing. Depending on the size of the room, a microphone may be needed. The hearings are open to the public, so there may be other people who are present and listening to your case. You may wish to attend a hearing prior to yours to see how they're conducted. Contact the appeals board to find out when hearings are scheduled. When asked to present your testimony, relax and speak clearly and slowly. And remember, you're not expected to have great public speaking skills. Just be yourself, be polite and respectful. Although your county may not have a strict rule on how long your presentation can last, concise and appropriate information is more likely to be heard and understood. In most residential property appeals, the assessor's representative will present the case first. For assessment appeals of owner-occupied residential properties, if you have supplied all information to your assessor as required by law, the assessor will be required to present the case first to prove that the enrolled value is correct. If sufficient evidence is not presented to show that the assessor has met that burden of proving the value on the roll, then you will not need to present any evidence to win your appeal. It is rare, however, that an assessor does not meet the burden of proof, so be prepared to present your case. When presenting your case, it is your responsibility to present independent evidence that you have produced to show that the value that the assessor has suggested is incorrect. Simply criticizing the assessor's case is not enough. After each side makes its presentation, the appeals board gives the other side a chance to ask questions about that party's evidence and testimony. When it's your turn for this, you should ask questions to show why you think the assessor's information is less reliable than your information. After questioning is completed by one side, the board members or hearing officer may then also ask some questions of the witness who testified. The same will be true when the other side has completed its questions. After that, each side will normally be invited to summarize their case if they wish. It isn't difficult to do this successfully. More often than not, and especially for single-family residential properties, the best summaries are short and simple. When it's your turn, remember to emphasize what you felt were the weak points of the assessor's case and the strong points of your own. When the presentations are completed, the appeals board will either make a decision on your appeal immediately or take the matter under consideration and render a decision at a later date. If they take the appeal under consideration, they'll provide you with a written decision within a specified length of time. You'll be told when to expect the decision, but if not, just ask. The appeals board can agree with your value, your assessor's value, or another value that they think is more appropriate based on the evidence presented. This is the value that will be enrolled on the tax roll for your property. However, this doesn't end your appeal rights. If you disagree with the appeals board's value, your next step in challenging that value is to claim a refund from the county for the amount of tax you believe has been overpaid. You must file a claim for refund with your County Board of Supervisors unless you indicated on your assessment appeal application form that your application also constituted a claim for refund. Please refer to Publication 30 on this point. The county supervisors will decide whether your claim is valid. If the claim is not considered valid, your final option for challenging the assessment is in Superior Court. If you're prepared to take your case as far as Superior Court, you should be sure to ask for written findings of fact before your appeals hearing begins. You can check with the clerk of the board to find out how to get written findings of fact for your hearing. There is a charge, so be sure to ask the clerk for an explanation and estimate of these charges. These further appeal rights are explained in much more detail in Publication 30. That basically explains what you can expect in the assessment appeals process of your residential property. And remember, there's much more to an assessment appeal than we could cover in the short amount of time we've had together. So be sure to get Publication 30, Residential Property Assessment Appeals. Publication 30 is available from your local assessment appeals board or your assessor's office and is also available on the State Board of Equalization website at www.boe.ca.gov. Click on Property Taxes and then on Publications. Publication 30 will refer you to more sources of information about manuals, law guides, and offices that can help you obtain the appeal information you'll need to present the best case possible. If you do what's suggested in this video and what's discussed in Publication 30, you'll have the best chance for being successful in your assessment appeal. Good luck, and thanks for taking the time to walk through the appeals process with me.